Okay. So good day to everyone. Again, this is Joe Rosen, president of and founder of Parkinson's Resource Organization. Actually, I'm going to say to you, happy 2021. It's an unusual year starting out, and certainly we went through a very unusual world last year, but we're going to make this one if we do all the right things. And today we're going to talk about things you need to know or things you should know right now. And that pertains to property in the state of California. That is, so I guess my plea to those of you listening today is that if you own or someone you know owns property in the state of California, listen in, because today we bring to you an elder law attorney that I've known for many, many years, and he is a proud coordinator of the Wellness Village, which is why we get to have these wonderful discussions with people like Attorney Remery coming on. And he has helped many of our constituents over the years with estate planning, with long-term care planning, and a plethora of other legal issues. So today, though, we are going to talk about Proposition 19, which passed in California this last election, and what that means, because there is a deadline looming here, and we want to inform you of that, tell you what the consequences of missing that deadline might be. So, welcome today, Mr. Bill Remery, and thanks for joining me. Does this pertain to all property in California?
Okay, so in a way, it does pertain to all property, or potentially could pertain to all property in California. Prop 19. This election year, everything was about the presidency and all the other, big ticket items. Prop 19 kind of slipped through without a lot of attention, but it relates to the assessed value of real property throughout California.
Thank you for saying that, because I was going to say, what does Proposition 19 mean? Okay.
So California, just for a little historical perspective here, California has a property assessed value system, and it's commonly called Prop 13 because that's the proposition, the constitutional amendment that was passed, back in the early 80s, that locked in your assessed value the date you buy a property, and then they can't reassess that property except for for inflation they can go up to 2% per year, and that's it. They can add 2% per year, but they can't reassess your property for tax purposes, no matter how valuable it gets, no matter how much the property inflates in value. They can't reassess you until you transfer the property.
Interesting. Okay.
At the time you transfer it, the typical one is a sale. The new buyer, it'll be reassessed up to fair market value when the new buyer buys it, and that locks it in at their Prop 13 number, and they can't go up more than 2% per year until they transfer. So that's Prop 13. There are different kinds of transfers. There's transfers on a sale. That's the easy one. There are transfers in divorces between spouses. There's transfers when somebody dies. There's lots of different kinds of transfers. So throughout the years, since Prop 13 came into place, to accommodate transfers that we don't really think of as transfers, when something passes to a child at death, we don't really think like that's like a sale. So they put in certain exemptions. Now, because Prop 13 is a proposition, which in California, proposition is a constitutional amendment. We actually change our constitution every time you pass a proposition. So it's not a regular law, then they implement it through other laws. But the proposition itself is a constitutional amendment. It has to be changed by another constitutional amendment. You can't just change a proposition by changing a law.
So Proposition 13 has been changed a few times?
Well, we've added new propositions to it, which qualify it, which then, up to this point, up to Prop 19, each of the other propositions expanded it and made it more liberal. For example, Proposition 60 said that someone over 55 could sell their home. And that in combination with Prop 90 and Prop 110, there were three different ones that said you can sell your house within your county And then Prop 90 said that a county or an adjacent county, if they participate, but with discretion with the county, there were limitations on it. And you roll your original tax base, how much you paid for your first house, into your new house, as long as your new house was purchased for at least $1 less than you sold your old house. So let's say you bought your house back in the 60s for $8,000. I've got clients like that. And they're selling now for $700,000, and you buy a new house for $600,000, you could roll that original $6,000 basis into your new property. Cool.
Yeah.
But if instead you sold your old property for $600,000 and bought the new property for $700,000, you couldn't roll your old basis. You bought a more expensive house. Okay.
Interesting. Okay.
So that was one of the exemptions, so that it and you can only do it once in your life. You could buy move your basis from one house to another house once in your life, and you had to be over 55. The next exemption that they put in place was Prop 58, saying if you want to transfer it to a child, we won't reassess you. Direct parent to child, we won't reassess you. Normally, people did this through their wills or trusts when they died, but sometimes during their life, they just transfer their house to their child, and the child got the same basis, the same tax base that the parent had. And then finally, this was expanded with Prop 193, I think. These numbers get all jumbled, but I think it's Prop 193 for grandchildren. If your intervening child died, so the grandparent wanted to leave it to a grandchild because their in-between child had passed away, you could skip that generation and it won't be reassessed, as long as the spouse of that child was also deceased or had remarried before the grandparent died. So if the daughter-in-law or son-in-law was married to their child when their child died, then you had to wait, either they had to remarry or wait until that in-between one died before you could pass it to a grandchild, otherwise it got reassessed. Otherwise you had to use the in-law.
In other words, you couldn't just transfer it from grandpa to the grandchild, skipping a generation. It had to be after a death.
Right. So not only your child had to die, but the other spouse of the child. Now, if they were already divorced when they died, that was okay. You could skip them. You didn't have to give it to your former in-law. But if they were your in-law when your child died, your son-in-law or daughter-in-law, you had to use them. You had to pass it to them, and then they had to pass it to their child. Okay. So that, anyhow, a little confusing. I don't want to get too much in the weeds, but you need to understand how things developed, because it's history is important in this case. Now let's look at Prop 19. Prop 19 was marketed primarily for its effect on that first group of people. Remember the 55-year-olds who could transfer their property?
Yeah.
But what they said with Prop 19 is, we're going to make it easier for people. Not only are we going to make it easier for people over 55, we're going to expand the pool of people who can roll their old assessed value into a new home. That's going to be for anybody over 55. Even if they want to move to a different county, even if they don't want to buy a house in the same county, anywhere in the state, you can buy a new house. If you buy a more expensive house, you can still roll your old basis in. We're just going to add the difference between the value of your old house and the value of the new house. We're going to add that to your tax base. So if you sold your old house for $600,000 and bought a new one for $650,000, we're going to add that $50,000 to your assessed value. But remember, your assessed value goes way back to when you bought it back in the 60s. Okay, so you still have a good benefit. Yeah. Okay, so that's the second advantage. And the third advantage, we're also going to open it up to people who lost their homes in the fires. And here again, now we get the sentimental pitch. We're going to open this up to all those poor people who lost their homes in the wildfires. When they buy a new home, we're going to let them use their old tax base. We're going to let them roll your old tax base into that new home instead of prior to Prop 19. When you bought that new home, you got charged based on the full assessed value. So good things. It expanded it for the taxpayer. And that's how it was sold. What was not emphasized for sure, it might have been mentioned somewhere, but in all the ads, they talked about the veterans, people who lost their homes in fires, and people over 55 being able to move their assessed value into the new home. That's how it was sold. On the back end of it, they said, oh yeah, but incidentally, remember how you used to be able to transfer to your child, and what was permitted under that old Prop 58, you could live a principal residence to a child of any value. The Taj Mahal, you can leave to your child and they won't reassess it. And then any other property up to $1 million in assessed value. So let's say you have an old apartment building, maybe it's worth $1 million now, but it's only assessed at 100,000 because you bought it years ago. So you can use that 100,000 assessment, give that apartment building to the child, and the child will have that same $100,000 assessment, plus your home. So you give the home and the commercial property all without being reassessed. That was the old Prop 58. Under Prop 19, all commercial property gets reassessed when you pass to a child. Doesn't matter whether it's a single family residence that they're renting out or whether it's an office building or an apartment building. If you transfer it to a child, it gets reassessed. That's number one. If it is a principal residence of the decedent, the parent, and they pass it to a child who will live in it as their principal residence, then they still get the exclusion. They get the Prop 58 exclusion, the old rule.
Okay.
Up to $1 million. Remember, on the old one, you give away the Taj Mahal. Under the new one, you can only give away the first $1 million.
Okay.
Some people who have property up in the hills here near me, I'm in Glendale, California, and when you're near the Hollywood Hills and stuff, it's not unusual for people who bought properties for $100,000 for them to be worth $1.5 million now or $2 million.
And then if you go to Northern California, San Francisco area, you also are in that same kind of category. Yes.
And Marin County and all,
Yeah.
certainly.
Yeah.
So now if you transfer that to the child, even if it was the parent's principal residence, and even if the child lives in it, what they will do is they will give you your original assessed value, give the child another $1 million of equity, and then anything on top of that, add it to your tax base. So let's say it's worth $1.5 million. Your assessed value is only 100,000. So the child gets it, they'll have it get that 100,000, but your equity is $1.5 million. So the top 400,000 they're going to add back to your assessed value. So essentially, you'll take the total value of the property, subtract $1 million, and that's going to be your assessed value. So if it's worth $1.5 million, you're going to pay $500,000, your taxes on $500,000. So
that doesn't sound so bad, does it? I mean, it does, but it's not.
Well,
Yeah.
but again, it only works if the child's going to live there. Now, if you have an older child and they already have their own home, and they just they inherited that property and they wanted to let their child live in it, or they wanted to rent it out, or they're going to let grandma live in it. It doesn't matter. Once it passes to that child, it gets reassessed fair market value.
Ooh.
And let's say it's just an even $1 million. I'll use that because the round numbers work easily. The property tax in California is basically 1.25%. There's a 1% tax across the board, and then there's usually about 0.25% in add-ons. So we figure 1.25%. So on a $1 million house, the property taxes are $12,500 a year, right? 1.25 times $1 million. Okay, so $12,500 a year. If you're going to rent the place out, well, you factor that into your cost of doing business and say, well, okay, it's going to be $12,000 off the rental value. But if you're actually going to keep it and maybe let your child live in it, or you're going to let your grandparent live in it, well, guess what? You just added over $1,000 a month just in tax. It doesn't add any value to your property. You're not getting any other use out of it. That's just the taxes.
Wow, that's like in the old days before we had Proposition 13 come in to play, where our property taxes just continually skyrocketed. And I think other states in the union are under that same kind of bias where the property taxes keep going up. Well, California, I think, is very special.
It is very special. In fact, we are the only state that has Prop 13. Arizona talked about it, but they haven't gotten to it. But in 49 of the states, every year they reassess your property. And then the following year, they give you the new assessed value. And the year after that, they impose the taxes. So there's usually a 2-year lag as the economy goes up and down. Because I remember I have a property in Arizona. And in 2007, 2006, it went down, down, down. Then it came back up. And there was a 2-year lag on that. It went down, down, down. The taxes went down. How cool is that? But then all of a sudden they started coming back up again. So it's very unreliable. So with Prop 13, part of what we get is some degree of certainty, as long as we own the property, that we know what our taxes are going to be. Go
Now,
ahead.
when we started out today, I said there was a looming deadline. And so let's not forget that there is a looming deadline. What does that mean? And what is that deadline?
That deadline is February 15, 2021. So in approximately 40 days, here we're in January 6th now. So on February 15, any transfer made after February 15 is subject to Prop 19. It's subject to the new rules. Up until February 15, you have the advantage of the old rules. So if you're gonna die and leave the house to your kids, today's the day to do it, because you'll get to pass it under the old Prop 13, Prop 58 rules.
It can be passed without death, right?
Correct. Correct.
Okay. All right. Okay.
So,
Because we don't want to force people to die today.
I understand. Well, and the thing is, as with any estate planning, the key to estate planning really is to keep all the balls in the air at the same time, right? Because yes, we have Prop 13 and the assessed value issue. That's one ball we got to keep in the air. Try to take advantage. How do we take advantage? Hey, move things before February 15 if it's going to go to the child. What if the child predeceases you? Oops, all that planning you did was premature because you're still here. Now that's going to their widow, or it's going wherever their estate plan says it go, where you really thought it was going to stay yours for as long as you were alive. Okay, so that's one issue. The second issue is if you give it to the child and then you die, the child has it and now don't get confused with the Prop 13 assessed value. Now I'm going to be talking about your basis, your tax basis in the property. This is what you paid for the property. And if you sell the property, you make a profit. So if you bought it for $100,000 and you sell it for $500,000, you have a $400,000 gain. It's called a capital gain, and you're going to have to report that on your income tax return next year. If your child receives the property from you during your life, they get your purchase value. If you bought it at $100,000, they own it at $100,000. If they sell it later, they pay the tax. If they inherit it from you, they get what's called a stepped up basis. They get the value at the date of your death. So if the day before you die, you give it to a child, they get it at $100,000. If instead they inherit from you the next day, they get it at $500,000, the value at the date of your death. If they turn right around and sell it, there is zero capital gain. It's a freebie. All that appreciation that grew during your life disappears at death. It's one of the few freebies you get from the IRS. You got to die to get it, but it's a freebie. All your appreciation disappears. It works with stock also. If you pass stock at death, it gets a stepped up value. But if you give it to them during your life, they get what you paid for it.
I think that this is so critical to give people an understanding of why estate planning is so important. And as you said, keep all the balls in the air. And then I will say that it's very important to go to the people, particularly those that we have in the wellness village or those that we might suggest that somebody goes to, we know have high integrity, understand what they're doing, are well qualified, well trained, and they can take the estate planning and do what I know that you do, taking in all of the issues that might come into play. Because there's more than one issue in doing estate planning. We talk about the long-term care planning. In the state of California, we use that as Medi-Cal planning. In the other states in the union, we talk about Medicaid planning. All of these are long-term care plans. They all need to be addressed as well. But that's not today's subject. I just want our listeners to know that it is an attorney like you, an elder law attorney, that understands all of the issues going through planning, especially when someone has chronic illness like Parkinson's, and can take the family through the ups and downs of the planning and bring to them the greatest quality of their financial plan and of their life plan. So I think that the Proposition 19 information is critically important to them right now. The deadline of February 15 is critically important to them right now. So what we've done at Parkinson's Resource Organization is you authored an article that we want the readers to know is available to them. It is on our website. It is called The Unintended Consequences of Proposition 19. So if you go to the website, you will see that. As we go through and we take this video and send it out over throughout the media. You also will have an opportunity to click onto the website to read that article. Please do. And then if you have any questions or any comments that you need to make, or you want to talk to Mr. Remery about his article or what we've discussed today, go to the Wellness Village on our website. There's a URL right down there. And do click on go to Elder Law or go to Remery, whichever one is easier for you to do. Click on Bill Remery's page and read about him, and then go to the article that's on the website called, again, Unintended Consequences of Proposition 19. I think this is such critically important and imminent information right now that we couldn't have pulled this off any sooner than this to make the impact that we're going to make starting today. So, Bill, I want to thank you just profusely. Is there anything you would like to add?
No, again, I don't want people to fixate on this. I don't want them to think the sky is falling. Just understand, with this deadline, if you're going to consider making a transfer to a child, or it could also be child to parent, incidentally. It works in both directions. I do have situations where a child might want to transfer to a parent and then get a step-up basis when the parent dies. I'm just throwing that out there.
Okay.
But it works the same way. That Prop 58 was a bi-directional thing, parent to child, child to parent. And so if there's a thought of doing that to try to take advantage of the Prop 13 issue, February 15 is your deadline. After February 15, life is still going to go on. There are still other issues. There's still the stepped up basis rule. There's still other reasons for doing your planning. But this one narrow thing is February 15. Now, all that being said, I personally have an idea that when people get more well versed on Prop 19 and they realize that this tail wagging the dog here of the change in the parent to child exclusion was kind of slipped in under the radar, that there may be a future proposition on the ballot to either reverse it out or to modify it in some way, to expand it in some way, to kind of bring it back to where it was. I would not be surprised to see that. So keep an eye out this year and maybe the following year when you get your ballot, your sample ballot. It talks about those propositions at the back. Don't ignore them. I know so many people who, they hear the most popular ones. They hear the ones that are on the radio or on the television all the time, but they don't read the other ones. I don't know if they vote for them or not, or they just arbitrarily just leave them blank. But issues like this, these are bread and butter issues. They do affect you. So not just these tax propositions, but all propositions you should read. There's a reason they're there. They're important. They get pushed typically by their advocate, the one who drafted it. In this case, almost the sole backer of this. If you looked at the advertising and the materials that came out with the sample ballots as to who was funding Prop 19, it was the California Association of Realtors. Now, why would that be? Is it the realtors are really worried about those people in the fires and being able to transfer their tax base in? Or were they worried about the fact that when a parent died, if it just transfers to a child, there's not going to be a sale? But if the child finds out, they transferred to me, now I got a $12,000 a year tax bill, I might as well sell the house. Who are they going to go to sell the house? So yeah. just an idea. Pay attention to who's funding things. And that sometimes tells you in terms of the actual proposition itself as to what the reasons are for this. So maybe it makes you more cautious, or maybe you say, oh yeah, I'm on board. I'm in with them. This is exactly what concerns me. It's the Union of Concerned Scientists or something for some pollution bill. Okay, yeah, if they're backing it, hey, maybe it is anti-pollution.
Yeah. It's education. We just have to continually know just everything. And whether it be on the political side, on the election side, on the living side, it's just everything that you know. Knowledge is power. It's been said over and over and over that that's so. And again, we say to all of you listening, that's what Parkinson's Resource Organization is about. And what we're doing for you listening is to bring you the most current, up-to-date information that we can. bring it to you in a timely fashion so that you can act on it. And it's all to help you gain a better quality of life as you go through life. So with all of that said, again, I'm going to say, Bill Remery, thank you so much for participating with me today in this video. And again, on the website is the article, Unintended Consequences of Proposition 19. Please take a look at it, especially if you have or know someone who has property in the state of California that wishes to transfer it to a child. Thanks very much, Bill. We'll be seeing you very soon at a village meeting.
Thanks, y'all. Good seeing you. Happy New Year.
Thank you.